start late, right? So, are we recording?
Yep.
Well, then let me say welcome to everybody. Happy, I guess, what are we? The third day of spring here, last day of March. I can't tell because it's about 60 degrees outside, and that's all I really care about. So, welcome to, I think I would call this the first real day of the spring semester because it actually feels like spring out there. Today, I'm going to talk about and kind of take you through the requirements for a patent. And these requirements sort of cut across all of the areas of intellectual property. So you'll find the same requirements essentially in copyright and in trademark law. But because there are essentially the same but more requirements in patent law, I'm going to use those as a way of illustrating the concepts that all three branches of intellectual property require in order to obtain protection for them. Protection in either the form of a copyright or a trademark registration or a patent. And next week, we're actually going to go over the constituent elements of a patent. I'm going to put you in the position of an applicant for a patent. We're going to go on the US PTO website, and we're actually going to go through how to file a patent application. So by the end of class next week, you will not only know the constituent elements that go into a piece of intellectual property in order to protect it, that is the essential qualities that qualify you for protection, but by the end of hopefully next lecture, you will not only know those things, but also know the things that must be included in your application in order to get protection. And it, of course, makes sense, but the two are very much related. So in order to demonstrate that your product is patentable, the application essentially asks you questions or asks you to disclose characteristics of your invention that prove that it meets the requirements that we're going to be talking about today. So everything that we talk about today are the things you're going to have to prove when we file a patent application and go through that process next week. And these things are elemental, but really describe the essentially the boundaries of what is and what is not protectable as intellectual property. All right, so when it comes to filing a patent application, of course, we go right back to the statute which Congress wrote that describes what is patentable. And that, I think we went over before, is Title 35 of the United States Code. And the first line of Title 35, Section 101, states that whoever invents or discovers any new or useful process, machine, manufacture, or composition of matter, or any new or useful improvement thereon may obtain a patent. That's what we lawyers call a kitchen sink definition, because I can't think of very many things that do not fall within that very, very broad statutory definition of what is patentable. And so that's where our analysis begins. To be patentable, something must be statutory. That's the first requirement. That's the statute that all of us have memorized and that I just quoted to you a minute ago. Anyone who invents or discovers any new or useful process, machine, manufacture, or composition of matter. And anybody think of anything that really doesn't come within that definition? Because if you do, I'd like to know. I can't think of hardly a thing that doesn't come within that statutory definition. So the first question you must ask yourself, or a patent examiner will ask about your invention is, does it meet the statutory requirement? Does it fall within that very broad definition? And almost every patent application or invention does fall within that. The second requirement that it must meet in order to be patentable is it must be novel. And by that, all that we mean is that the invention must be new. The novelty requirement is a simple one, but a very important one. The other thing that an invention has to be patentable, it must be useful. In other words, it has to do something. It has to, a mousetrap has to catch mouses. A line of code has to that is expressed on a hard drive or on a computer must do something. In other words, it has to be useful in some way. And this word comes right out of the statutory language. The last thing that an invention has to be is non-obvious. And that's a very important requirement, and one of the tricky parts of patent law, and one that we'll talk about. It is, of all of the characteristics, the most subjective and difficult one to define. But all of these characteristics, that it be statutory, novel, useful, non-obvious, are things that are repeated over and over again in intellectual property law. In order for something, for instance, to be copyrightable, the statute that pertains to copyrights, Title 17 of the United States Code, again, the first section, Section 101, talks about how in order for something to be copyrightable, it must be an original work of authorship. So that originality requirement, the novelness requirement, the fact that it's unique is something that is reflected in the law governing copyrights. And the same thing goes for trademarks. Trademarks, the statute on trademarks, the Lanham Act, talks about distinctiveness, okay? And for something to be able to be trademarked or registered as a trademark, it has to be distinctive, it has to be unique, it has to be new or novel, and capable of being identified with a product. And in fact, in trademark law, there's basically whether something is trademarkable depends on where it falls on the spectrum of distinctiveness. You know, on one end of the spectrum, you have something that is completely new and unique. And on the other end of the spectrum, you have something that is generic. If it is generic, it's probably not something that can be protected by trademark. The more distinctive a particular sign or symbol is, the more likely it is to be trademarkable. So let me go through these four requirements and talk a little bit about each one so that you get an idea of what you're going to have to prove to the patent examiner when you file your patent application, okay? So in order to be statutory, as I said, that is such a broad definition that includes plants, animals, DNA sequencing, mechanical devices, designs that are unique. It really covers just about everything that you can think of that is made up of matter. So it might be easier to talk about what is not statutory in order to define what statutory means. What is not statutory, as far as patents are concerned, is anything that is considered a functional description of material. A data structure of some type would not be something that is patentable. Now, you may be able to get protection as copyright for something like that, but it's not patentable unless and until it is combined with a machine that does something. But something that is purely consists of a data structure or a functional description of a process or a method is not patentable. But as I say, there may be overlapping protection when it comes to copyright. I'll give you some examples of things that are non-functional: books, literature, compilations of data, and software when it has not been combined with a device. Electromagnetic signals radio waves are not patentable. Any forms of energy, gravity obviously is not patentable. But you'd be hard pressed to go beyond those very fundamentals and find anything that is not ultimately patentable, given the very broad definition that exists in this country.
Perpetual motion machines.
Perpetual. Well,
people try.
As long as you can satisfy the usefulness requirement, I think that it would be patentable. I haven't researched that, but I may take a look and to see how many applications for perpetual motion machines have been turned down by the examiner, because of course the examiner would have to determine that it does what it says it does. Any abstract idea is not patentable. But if it's not abstract, if it's expressed in tangible form, it's probably patentable. And that's, and by the way, this country has, I think, in the world, the broadest definition of what is patentable. If you go to countries like China and Canada and France and the United Kingdom and Spain and Italy, you'll find a much narrower definition of what is patentable in some cases. Although as time has gone on, they tend to migrate towards the United States method of sort of a kitchen sink description. But still in the United States, we have the broadest statutory definition of what is patentable. Anyhow, let's go to the novelty requirement or the requirement of newness. And this basically comes down to one thing, and that is whether or not the invention has been disclosed. I've said it before, I'll say it again at the risk of being borderline obnoxious about it. If you have an invention, if you have something that's worth protecting by patent, file a provisional patent application. And that's because of this requirement, the novelty requirement, because the minute you disclose your device, and I mean, even if you're sitting at a bar in Cambridge having a pizza and you happen to tell a colleague about it, that amounts to, in most cases, a disclosure. And under the rules in the United States, you have 1 year from that date, that is the date of disclosure, within which to file a provisional or a patent application. If not, your idea goes into the public sector. Now, that does not include the fact that the person that you disclose it to may run down to the patent office, and by that I mean nowadays opening up their MacBook Pro, going on the USPTO website and filling out an application for a provisional patent application. If they do that before you do that, they win the race to the steps of the United States Patent Office and they get the patent. So disclosure in the absence of a non-disclosure agreement, a secrecy agreement, a confidentiality agreement, any disclosure at all, whether it be at the bar or whether it be at a symposium, a professional symposium, a lot of people trip up at these things, whether it's offered or disclosed to investors for potential investment. Any form of disclosure at all starts the clock ticking. And you have 1 year, at best, you have 1 year from that date within which to file your provisional patent application, or your disclosed device, your invention that's been disclosed, goes into the public domain. And I say at best because anybody who hears that disclosure, comes across that disclosure, and files an application before you do, gets the rights to the invention. That wasn't always the case. And until 2011, the United States was out of step with the rest of the world and said that whoever invents first owns the rights. But in 2011, the law in the United States changed to bring us into conformity with basically the rest of the world, which is a first to file country. So before 2011, we were not a first to file, we were a first to invent country, unlike most countries in the world. Beginning in 2011 with the new statute governing patents, we became, along with the rest of the world, a first to file country. And that is very important to remember, because any disclosure of your device without filing an application first could defeat the novelty requirement, and all of your rights will go up in smoke. Now, I want to talk about the novelty requirement as it pertains to other countries, because this novelty requirement is different from country to country. And if your invention has commercial applications outside of the United States, you need to be aware that the novelty requirement changes from place to place. For instance, in the United States, you have, as I said, 1 year within which to file your patent application from the date of your disclosure. And you will be awarded the patent. All you have to do is prove is that you disclosed first. But the problem with that is, if you go to another country, that 1 year grace period does not exist. So there's what's called in the patent world absolute novelty and relative novelty. The United States is a relative novelty country where you have 1 year, you have that 1 year grace period. But if you go almost anywhere else, there is no grace period. So if your invention has commercial applications that you'd like to exploit in China, Japan, Germany, France, Italy, the United Kingdom, Spain, if you want to exploit your patent commercially in any of those countries, you must not have disclosed first. If you've disclosed first and someone else beat you to filing in those countries, they own the patent, because they are absolute novelty jurisdictions. Again, that's why whenever anybody comes into my office and they say, gee, I'm thinking of disclosing, the first thing I say is file a provisional patent application. It's a cheap, easy, efficient way to protect your intellectual property, and it avoids the pitfalls of competing jurisdictions, absolute novelty jurisdictions versus relative novelty jurisdictions, jurisdictions with grace periods, jurisdictions without grace periods. So you always err on the side of filing a patent application before you even mention your invention to anyone else, absent a formal non-disclosure or confidentiality agreement. File the patent application before you disclose, before you write your paper, before you solicit investors, before you go to a dinner with someone and talk about what a brilliant idea or invention you have. File the application first in order to protect your rights, not only in the United States, but in other jurisdictions where you may want to commercially exploit your device that don't play by the same rules that we play by here. Relative novelty jurisdictions include Canada, places like Mexico, Brazil, Argentina. Chile, Mexico, most of the South American countries. And the reason for that is pretty simple. They basically developed their patent system after we did, and they copied our system of patent laws. Most jurisdictions around the world have followed a basic format, either reflected by the World Trade Organization or the United States. So if you're a new country or a country that's just developing its intellectual property system of laws because you're developing a manufacturing base and you need one, what you generally do is you go and you copy what other people have done. Most of the world has copied the absolute novelty requirement, and so file your provisional patent application before you talk about your invention, so as to not have the novelty requirement frustrated. No novelty, no patent. All right, so I think I've covered that sufficiently. I want to talk about usefulness. The term useful in this context means it has to do something, all right? Usually this requirement is pretty easily met, except perhaps in Professor Eager's example of a perpetual motion machine. Unless you can demonstrate that the thing does, you might have to be able to demonstrate that the thing does what you say it's going to do. If it doesn't do the thing that you say it's going to do, it's not patentable. And you're going to have to demonstrate that to the patent examiner. This is one of the reasons why in the old days we used to have to actually make an exemplar of the machine that we seek to patent, so that we can demonstrate to the patent office that it does whatever it is we say it does. Whether it catches mice, or if it's a Gatling gun that it fires so many rounds per minute, or whatever the invention happens to be. It has to have usefulness, and you have to be able to demonstrate that. Nowadays, we don't do that. We don't have to create an exemplar for the patent office, but we do have to provide diagrams in detail which demonstrate how the invention works. And with computer-aided design and graphic arts the way they are, patent applications can get pretty sophisticated when it comes to the figures or the drawings that are submitted, demonstrating the usefulness of the technology that you want to patent. So not only need it be useful, but it has to have what the courts call, or the U.S. Patent Office calls, operativeness. And by that, I mean it not only needs to be useful, but it must be able to do the things that you say it can do. So usefulness is synonymous with operativeness. And that's the word that you'll find the patent examiner using when they call you to question whether or not your patent application actually demonstrates an operative device, something that'll do what you say it will do. Now, there in the usefulness category, especially when it pertains to you, anybody focusing or majoring in any of the biological sciences here? All right, well, one of the areas where this term operativeness has come into controversy has to do with the biological sciences. The development of large-scale DNA sequencing, for instance, has enabled us to identify all kinds of DNA sequences. And those DNA sequences are actually patentable as processes. But the controversy comes in where the DNA sequence, where although we are able to isolate it and identify it, we are not able to understand fully what it does. And so when DNA sequencing was first eligible for patenting, a lot of patents were granted to folks that had isolated a particular DNA sequence, but without fully understanding what that DNA sequence could do. So for instance, if you isolate a DNA sequence which makes a plant capable of growing deeper roots or shallower roots or bigger leaves or larger fruit, that DNA sequence which you have isolated is patentable. But what the applicants would do in those days, and usually they're these giant engulf and devour companies like Monsanto and the others you've heard about, but when they would file their patent application, they would file claims. That is, they would make claims concerning the technology they are trying to patent that were very broad. And in addition, the applications would say, you know, in addition to greener leaves or prettier flowers, it'll do everything else. And they get a patent application. And then what they would then do is they would try, as follow-on technology came along, they would try to control the market by filing infringement actions against follow-on technology, which developed from the basic patent that was filed, but which had not yet been demonstrated. And so what the patent office has done over time is it's applied this operativeness definition to things like gene sequencing. And it says basically that if you've developed a method for sequencing DNA that has some application, in order to be patented, you must demonstrate the application that it is useful for. And anything that you can't demonstrate, you can't claim. So the claims section of an application, a patent application, as we'll find out next week, describes what your invention will do. And if it happens to be, in this case that we're talking about DNA sequencing, you have to include in the claims section all of the things that you have been able to demonstrate that your method will do. And the examiner will call you on it. The examiner will say, show me how, or prove to me how your invention is able to do the things you say it can do. And if, for instance, you've demonstrated that your gene sequencing technology is useful for treating cancer in rodents, but you haven't been able to demonstrate its efficacy in human beings, then all you're going to get a patent for is the technology that you've been able to demonstrate the efficacy for in rodents. And if somebody then comes along building upon your technology and then can demonstrate the operativeness or effectiveness or efficacy in that technology for primates, then they're going to get the technology for that. In the old days, what they would do is they would grant very broad patents on technologies that had not been demonstrated, and that led to an awful lot of litigation, an awful lot of challenges to patents. So now the USPTO and the courts, for that matter, have quite correctly clamped down. Now, you've probably heard of the CRISPR decision, or the CRISPR gene editing technology. There was an enormous case that involved the CRISPR technology that was brought by the California Institute of Technology, which developed the original sequencing technology, but they weren't able to demonstrate the usefulness of the technology in Homo sapiens, in primates. They were able to demonstrate the technology in lower biological forms, with respect to microbes and some very rudimentary plants. but they were not able to demonstrate the efficacy of the technology when it came to human application. And so when the Broad Institute, right over on in Kendall Square, came up with a application of the technology that showed the technology to be efficacious with respect to human beings, they filed and were awarded the patent on it. The people in California brought suit against the Broad Institute, saying that's our technology. What you've done is something that we've protected, and the Caltech people actually did file a patent that was very broadly worded, but the USPTO, in deciding the case, decided that because the Caltech people were not able to demonstrate the efficacy of the technology when it came to humans, they decided that their patent would be limited to what they were able to demonstrate, and the Broad would be entitled to a separate patent on what they were able to demonstrate. And by the way, talking about loose lips and disclosures and things like that, what sunk the original patent holders in the CRISPR case was that their scientists, when they were interviewed by publications like the New York Times, were very candid in what they were able to demonstrate by their technology. And they admitted to reporters at the time that they had not yet been able to demonstrate the efficacy of the technology in human beings. And of course, when the trial came up and the issue became whether or not they've been able to demonstrate the efficacy of the technology they were claiming to control in human beings, the scientists' interviews to the New York Times were used against them. So you have to be careful what you say when it comes to your technology, whether it happens to be in the claims section of your patent application or to a reporter from the New York Times, because those words will come back to haunt you insofar as the United States Patent and Trademark Office has one response to those kinds of things: prove it. And nowadays, you have to prove it. You have to prove the operativeness of the technology, or you can't get patent protection for it. So it has to be statutory, it has to be novel, it has to be useful, and within usefulness, it means it has to be efficacious, operative. So the last requirement that you have to satisfy in order to be entitled to patent protection is non-obviousness. And I've saved the best for last, because non-obviousness is the squishiest and most subjective and most difficult to define of the four requirements for a patent. And so what is meant by non-obviousness? If the invention is the same as prior art, then it's considered obvious. So maybe the best way to talk about this, maybe the best way to demonstrate the concept, is to tell you about what happens to your patent application when it comes into the United States Patent Office. When it comes into the United States Patent Office, it'll be signed an examiner. Now, they have examiners down there that specialize in almost every area of technology. They have mousetrap experts, they have DNA sequencing experts, they have design experts, they have experts that are familiar, many of them with PhD degrees, or at a minimum advanced degrees in material science, in mechanical engineering, in technology, in biotechnology. Every area across the spectrum, there's an expert sitting in the United States Patent and Trademark Office who will be assigned to your application. Now, when your application comes in, they literally go through the checklist. Does it satisfy the statutory requirement? Does it satisfy the novelty requirement, the usefulness, and the non-obviousness requirement? That's what the examiner needs to do. They only have 4 things on their checklist. In order to determine whether or not it meets these qualifications, what they will do is the first thing they will do is they'll study the prior art. Now, these examiners are really skilled. This may be your first or even your 10th patent application, but I can assure you that the examiner who is going to be looking at your application is far more familiar with the prior art than you are, because they've probably been dealing with it for 15 or 20 years. So if it comes to DNA sequencing or mousetraps or material science, trust me, the examiner that is assigned to your invention will probably know at least as much as you do about the technology, and probably much more than you know about the prior art. And the first thing they'll do is they'll go to the prior art and they'll look at all the other patents for mousetraps. So they'll look at all the other patents for DNA sequencing that do what you say your invention does. And they're going to try to determine whether or not the elements of your invention are sufficiently new, are sufficiently novel, have placed sufficient distance between you and the prior art to be considered novel or non-obvious. So an invention that comes into the patent examiner's office that is exactly the same as the prior art is going to be rejected. Not because it's non-statutory, but because it doesn't satisfy the novelty requirement. It's been done. If it's been done, it will be rejected. And that's even if it's useful. Now, if the prior art, if there isn't an identical prior invention, what the examiner will then do is look at all of the other inventions in the category and try to find out whether or not the elements of your invention are present in other inventions. Maybe not all in the same one, but maybe reflected in prior art. So if your invention does three things and they find those three things all in one other example of prior art, then it's not novel. But if they find those three things in three separate prior patents, prior art, then the question becomes whether or not your invention is non-obvious. So the standard that the examiner will apply is considered it's described as or known as the obvious person standard. And the question the examiner is going to be looking to determine whether or not your invention is non-obvious is whether or not to a person or an expert in that particular technical field, whether or not your invention was obvious. So if we're talking about the field of DNA sequencing, that case also involved the non-obvious defense. When the Broad was accused of infringing on the University of California's patent involving the CRISPR technology, one of the defenses that the Broad brought it was actually a cancellation action in the United States Patent and Trademark Office. But one of the defenses raised by the Broad was that their invention was non-obvious. University of California said, well, wait a minute. You're using essentially the same gene sequencing technology. You're using essentially the same vector that is described in our patent. So what if we haven't been able to demonstrate it in anything larger than a mushroom? The fact that you are now demonstrating it in human beings is of no moment, because you're only building on the technology that we have already patented. And therefore, your invention, the Broad, does not satisfy the non-obvious requirement. In fact, you're just building on something that we'd already developed and demonstrated. And so what you did was really required no skill, required no inventiveness, required no, it was not unique in any way when it comes to what is ordinarily understood in that technology. And there was tons of evidence from scientists conversant with this type of DNA sequencing at the trial on the issue of whether or not the technology was obvious or non-obvious. And of course, the University of California had put experts up on the stand that said that this technology that the Broad Institute was attempting to patent, or it actually had patented at that point and been granted a patent, was obvious, and they should not have been granted the patent. And the Broad brought their experts in and showed, by comparing what they did with what the University of California had prior accomplished, by comparing the two, they demonstrated to the satisfaction of the United States Patent and Trademark Office that their invention did satisfy the non-obviousness requirement. And that is, their scientists were able to show that their technology put sufficient distance between what the prior art had established or had demonstrated and what they were able to demonstrate. So this non-obvious factor is very much related to the operativeness factor, at least nowadays in terms of how these things are viewed by the United States Patent and Trademark Office and the courts. Whether or not something is non-obvious really relates to whether or not you've been able to demonstrate its operativeness before. Under this subjective non-obviousness standard, the examiner or the court or a jury would be asked to take a look at the prior art and determine whether or not the prior art had demonstrated the technology or not. If it hadn't demonstrated the technology, for instance, in this case in human beings, and had only been able to demonstrate the technology in single-celled animals, then they weren't able to satisfy the operativeness element, and the follow-on technology is considered non-obvious. So that's, I think, the best way to describe what happens and how non-obviousness and operative and novelty are all sort of related. As I said, it's a very subjective standard when it comes to the courts and the U.S. Patent and Trademark Office. So you have to be ready to argue with your examiner and show them why your technology does create a gap. And it may take showing flaws in prior patents that may be too broad in terms of the claims made. If a prior patent makes a claim that had not been demonstrated, and you know that because of the work that you had done in the field, you would argue to the claims examiner, hold on a second here. That patent that they're trying to enforce is too broad. They weren't able to demonstrate the technology, therefore they failed to satisfy the operative requirement. Their technology or their patent should be limited to what they can demonstrate. And mine, because it goes beyond that, is eligible for separate patent protection. So you need to be prepared to have that dialogue with the examiner. By the way, it's at least nowadays a year from the date that you file your provisional patent application to you getting any kind of decision or dialogue going with the United States Patent and Trademark Office. So one of the good things about filing a provisional patent application is it gives you time to develop your technology in preparation for the eventual dialogue that you're going to have with the patent examiner about it. And in that period of time also, you can decide whether or not that technology is worth protecting with a non-provisional full-blown patent application. So there's no reason not to file a provisional patent application. There's absolutely no downside. And in fact, it allows you to buy time to develop your technology, to prove your concept, so that when you finally get that call from the patent examiner, you're ready to demonstrate that it's statutory, novel, useful, and most importantly, non-obvious. And if it's rejected for non-obvious, for not satisfying the non-obvious requirement, you'll be able to come back at the examiner and show where the examiner was wrong. And oftentimes we have success in getting the examiner to reconsider and change their mind when we can sit them down with the inventor, who may know much more about that particular discrete technology than the examiner, and convince them that the technology satisfies the non-obvious requirement. So there's a couple of cases that have interpreted this, and I'm only going to mention them to you because they are absolutely useless. One is called the Graham versus John Deere case, which is a Supreme Court case that talks about the obviousness test. And in that case, what the court said is that the non-obviousness requirement is a reflection on what society deems worthy of protection. So they talk about the balancing test that I talked about in this course, maybe I think at the first or the second lecture. You know, what do we decide to give patent protection to? And we as a society, when we grant these exclusive rights, in the case of a patent, 20 years control of a market. In the case of a copyright, a lifetime plus 70 years. In the case of a trademark, forever. When we grant these very valuable rights, there has to be a good reason for it. And so we as a society only grant these things, this exclusive right to control a market, if you have actually satisfied all these requirements and proven that your invention is actually an advancement in the state of the art. Because as a society, we only protect advances to the state of the art, because that's how we benefit. If you have not advanced the state of the art, if you're just doing the same thing that's been done before and you don't create any daylight, then it's non-obvious. Then it's obvious. It doesn't satisfy the non-obvious requirement, and you don't get protection for that. So that Supreme Court case kind of talked about the social importance and the reasons for these protections. And then there's another case called Ksr versus Teleflex, which is another useless Supreme Court decision. It involves a company called Ksr that had developed a throttle manipulation device. And they get sued by another company, Teleflex, saying, hey, your invention infringes on our patent because this technology, this throttle control technology, is our invention and ours alone to control. And KSR's defense in that case was pretty unique. It said, well, we can use this technology because your patent is no good, because your patent doesn't satisfy the non-obviousness requirement. This throttle control technology is just built upon prior art. It really didn't advance the profession in any way. And the Supreme Court agreed. They said that the Teleflex patent, which Teleflex was trying to protect, was null and void because it didn't satisfy the non-obviousness test. And I only mention the case because the Supreme Court in that case gave us the only guidance that we've ever had, meaningful guidance, when it came to the non-obviousness requirement. And that is, the Supreme Court says you'll know it satisfies the non-obvious requirement when you apply common sense. And they actually use those two words. So the non-obviousness test is decided based upon common sense. The trouble is the Supreme Court never defined what it meant by common sense. So common sense means whatever the patent examiner may decide it means, or what a particular court may, or a particular judge or a particular jury may decide what it means. But it does talk a little bit about what you need to know in order to determine whether or not something is non-obvious. If applying common sense to the invention, what you're trying to protect doesn't do anything new, then it's probably not satisfying the non-obviousness requirement. I've got about 2 minutes here. I want to do a little test in order to demonstrate obviousness or non-obviousness. Ways of, again, one way of defining what is obvious and what is not obvious maybe is to talk about what obviousness isn't. So if you have an invention and you change the color of the invention, okay, you probably aren't satisfying the non-obviousness requirement because you're not putting sufficient distance between you and the prior art. If you're changing the size of the invention, let's say it's exactly the same as a mousetrap that's been patented before, but you just make it smaller, you're probably not satisfying the non-obviousness requirement. A change in a material, if the thing that comes over the top and breaks the little mouse's spine is made of steel instead of aluminum, you're probably not satisfying the non-obviousness requirement, again, unless you can prove to the examiner that your use of a different material or your use of a different color or your change in the size of the device creates something new, something unique. So I want to share with you, for purposes of this, and I always get this wrong, so I'm going to try to share a screen. And you tell me if you can see it. Can you see that? So
Yes,
this is actually a claim from a patent application on actually a patent application made to the USPTO office. And the claim is a blade for a ceiling fan, said blade incorporating or constructed of phosphorescent materials, said ceiling fan being arranged for attachment to a ceiling. So basically what it says is we want to patent a ceiling fan. And in this particular case, the only advancement from the prior art is that we're changing the color of the fan. In this case, it's going to be in phosphorescent material. Is that patentable or not? Anybody have any idea? All they're doing is changing the color of the fan. Well, the answer is on January 7th, 2014, the Patent Office granted a patent to this. I would have got this wrong on the test. I'd still get it wrong on the test today if I was asked, because I would bet my life that you couldn't patent a ceiling fan where the only difference between it and the prior art is a different color. But there's the patent, and there's the diagram of it. To me, that's just a ceiling fan, but to the inventor, they were able to show or demonstrate to the examiner that because they make it or they cover it in phosphorescent material, it somehow is unique. I'll bet you dollars to donuts that if this had gone to another examiner, it may not have been a successful patent application. There's a great deal of subjectivity built into the system. And I think this is the best example of the subjectivity that I can think of. It's just a plain old ceiling fan. Doesn't do anything different, except in this case, it glows in the dark. I guess what this is a demonstration of is that what all you have to do is show that it does something unique, and all you have to do is cover that distance, a very small difference. Any small difference between your invention and the prior art even if it happens to be the color of the device seems to be, at least in some cases, satisfactory to the USPTO. And that's the best example I can think of to demonstrate the subjectivity of the non-obviousness requirement. So those are the elements you have to that you have to have in your application. In the application we go over next week that we're going to file with the USPTO office, we're going to have to include information to demonstrate that it's statutory, that it's novel, that it's useful, and that we can demonstrate its efficacy, and that it's non-obvious. And we'll get to that next week. Any questions? Everybody cool with that? This is not brain surgery. It's pretty simple. It's A, B, C, D. Every single application, no matter how complex or simple the device, has to satisfy just these 4 constituent elements of the statute. If it satisfies those elements, you're in. And it doesn't matter whether your technology is complex or very simple. The test is the same in each and every case. Every application has to demonstrate these 4. Nothing more, nothing less. Okay? Everybody cool? I'm going to be very interested in watching your presentations. I tell you, the best part about this course is that I get to watch you talk for a change. And so I'm going to, if you don't mind, be attending some of your presentations. I'm really looking forward to them. But if anybody has any feedback, any questions about this stuff, shoot me an email and we can talk further about it. But next week, we're going to actually get into the patent application itself. You're all going to be experts by this time next week on how to file a patent application. All right? Okay.
Okay.
I have a question.
Yes, please.
What's the logic behind giving a patent to the person who files versus the inventor?
The logic behind getting a patent.
No, giving it to the person who files versus giving it to the inventor.
Oh, you're talking about the first to file.
Right. Yeah. Why did they change that?
In the United States, for the longest time, we were not a first to file country because what we wanted to do was to promote basic research. And so what we decided as a country is that, by requiring people to file first, we were inhibiting, remember we talked about last week, the dissemination of scientific knowledge. The reason I think that we got away from that was simply because the overwhelming trend around the world, and because the world is shrinking every day when it comes to the commercialization of inventions, the logic behind becoming a first to file state is that we wanted our inventors to be able to commercialize their inventions around the world. So we decided to play by the same rules. We decided to give in a little bit when it came to the dissemination of scientific information in order to allow inventors to commercialize their inventions. But the good part about it is the way we did it with these provisional patent applications, which you can't get in other countries, all right? We pretty much preserve the best of both worlds. As we'll see next week, a provisional patent application is a very simple thing. And so the threshold in the United States, being a first to file country, is very low. You don't have to spend a lot of money on the application. You don't have to develop the technology substantially. It's really about as low as the threshold can be. And so we sort of preserve the best of both worlds. Our inventors can compete and exploit their inventions commercially, and we don't inhibit the spread of scientific knowledge by requiring a very high threshold when it comes to the application. So we've kind of split the baby in two by doing it the way we've done it. And it's unique in most of the world. You don't find this in China. You don't find this in any place in Asia. And you don't find it in Europe. So in some ways, our inventors have an incentive. And that's why so many people from all over the world file here in the United States. Okay, have I answered that question?
Yes, thank you.
Okay, anything else? Everybody cool? All right, I look forward to seeing your presentations. I look forward to seeing you next week when you all become experts in how to file a patent application. Cheers, everybody.
Thank you.